Mootness is the opposite of ripeness. Ripeness asks too early, but mootness asks too late. And like every justiciability doctrine, courts use it to control their docket. The rule is simple. If events after you file your suit end your injury, your case is moot. Federal courts need a live controversy. If the dispute is resolved or your injury disappears, the court loses jurisdiction. No more cases or controversy under Article 3. Sounds logical. You can sue, you win or lose, dispute over. But litigation takes years. Most injuries don't last that long. So courts created an exception, capable of repetition yet evading review. Take Roe v. Wade in 1973. Jane Roe sued Texas to challenge its abortion ban. By the time the case reached the Supreme Court, she'd already given birth. Her pregnancy was over. Texas argued the case was moot. She's not pregnant anymore, so there's no injury to remedy. The court said this is absurd. Pregnancy lasts 9 months. Litigation to the Supreme Court takes years. Every abortion case would become moot before decision. The challenged law would never face judicial review. So they created an exception. If the injury is too short to be fully litigated and it could reasonably happen again to the same plaintiff, the case is not moot. 2 requirements here. First, the injury must evade review. Too short-lived for the litigation process. Second, it must be capable of repetition to that same plaintiff. Both are necessary. This exception sounds broad, but watch how narrow it is in practice. Election cases get it. A candidate challenges ballot access rules for the 2024 election. The election happens while the case is pending. Moot? No, because the same candidate will face the same rules in the next election, capable of repetition to the same plaintiff. But one-time injuries? Moot. In DeFunis v. Odegaard in 1974, a law student challenged affirmative action in law school admissions. By the time the case reached the Supreme Court, he was already graduating. The court said, moot. He's getting his degree, he won't reapply, the injury won't reoccur to him specifically. That's the trap, to the same plaintiff. It doesn't matter that the challenged policy will affect thousands of future applicants. It won't affect this plaintiff again, so it's moot. Here's the timing squeeze the standing doctrine creates. You can't sue until you're injured, that's standing. You can't sue too early, that's ripeness. But if your injury resolves during litigation, and most do, your case is moot. The window for getting a decision is impossibly narrow. And courts use mootness strategically. Post-doc, watch how COVID emergency order cases suddenly became moot. The orders expired, cases are moot. Never mind, they'll happen again in the next emergency. Immigration detention? You've been released. Moot. Eviction moratoria? Expired. Moot. The capable of repetition exception was created to prevent laws from evading review. But courts control when it applies. Abortion? Exception applies. Other short-lived injuries? Moot. It's another tool for deciding which cases deserve decisions and which ones disappear into procedural dismissals.